The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the second NESOL webinar for 2018. And this is Karen Rollins speaking from the Center for Invasive Species and Ecosystem Health at the University of Georgia. We are hosting the webinars with the National IPSI. And speaking first will be Alan, and I'm sorry, Alan, if I mispronounce your name, Pleas, and Joe Pinesco. And our overall topic will be legal issues surrounding invasive species management. And after Alan and Joe, Helen Spites will speak, and then Stephanie Otts. And I'm turning the time over now to Joe and Alan. And Joe and Alan, I still can't hear you. Okay, and I do have your PowerPoint up, and this is showing from your screen through the webinar. However, I'm not getting sound from y'all, and I'm not showing you. In the chat box, attendees, would you let me know if you can hear the speakers?
Karen, I don't know if it would help. This is Stephanie. We can switch the order and I could go first while they work on their connections.
Okay. Joe and Alan.
Okay. Can you hear us now?
Yes, we can.
Oh, hi, Joe. Yes.
We used the wrong pin, audio pin, when we first dialed.
Okay.
So.
Okay.
All right. So, yeah, we're here together and ready to go. So I'll turn it over to Alan first.
All right. Great.
Yeah, so my name is Alan Ployce. I'm with the Washington Department of Fish and Wildlife, and we're just going to give you a brief overview of the Vessel Incidental Discharge Act as it's currently in play. Primarily, we'll be talking about the version Senate Bill 168.
All right.
And we're looking down lower.
There we
You
go.
So this slide 2 talks a little bit about the history here. It's pretty complex, but basically back in the mid-1980s, we had zebra mussels come into the Great Lakes. That's down in the lower left in red. That triggered off a lot of different issues and started the whole process for ballast water management, primarily through the National Aquatic Nuisance Prevention and Control Act of 1990. And that was further, a new version came out, National Invasive Species Act of 1996. Those directed the Coast Guard to start doing ballast water management in the United States. Primarily, they were voluntary ballast water exchange up until 2004, when the Coast Guard made ballast water management a national requirement for ballast water exchange. States were also became players in ballast water management back in the 2000-2004 era, primarily Washington, California, Hawaii, Oregon. I don't mention the Great Lakes states in here, but that was about the time when Great Lakes started getting involved and having their own programs as well. Primarily because the federal requirements were not sufficiently protective of our state water resources. So along that line, a lawsuit was filed in 2008 against the Environmental Protection Agency. That lawsuit came to fruition in 2008 when EPA was directed to also manage ballast water as well as other incidental discharge streams. So in 2008, they came out with their first vessel general permit And it had a lot of similarities to the Coast Guard requirements, but of course some more permit reporting issues that were not required under the Coast Guard. So also in 2005, that's when Congress started putting out new bills to try and subjugate or preempt state rights from managing ballast water. So back in 2005, Senate Bill 363 was one that sort of kicked it all off. And since then, there has been numerous congressional acts trying to deal with vessel incidental discharges. That's in the last column under Congress in the blue type. Most currently, what we're dealing with right now is we have the Coast Guard requirements, we have the EPA requirements, and we have several states that have ballast water requirements. And 2017 saw the most current version of VITA, Senate Bill 168. It was amended into Senate Bill 1129, which is the U.S. Coast Guard Authorization Act, but it was basically the same version as under 168. So affected states, states with active ballast water management programs, there's about 10 of them right now: West Coast, Great Lakes, East Coast, and I define active by means that a state has issued and enforces one or more ballast water management requirements, or they enforce federal requirements for covered vessels. So there's really only a handful of states that actively manage ballast water programs. As I noted, there's a number of incidental discharges that are also covered under VITA, and that applies to all states. So that was the third bullet. So the second bullet is which states have unique ballast water discharge standards different than the federal standard. And there's really only one that actively has a different one, and that's Michigan. California is currently using the federal standard, but they have a higher standard on standby in 2020, but only if commercially there's treatment systems that are commercially available, which at this point we would say would be highly unlikely. Next. So the key provisions under Senate Bill 168, covered vessels include all commercial and fishing vessels. It covers 36 incidental discharges, establishes a national uniform ballast water discharge standard. States can petition the Coast Guard to revise best management practices if on incidental discharges, if revision would substantially reduce adverse effects. So it's a pretty high standard. VITA would also eliminate all Clean Water Act authorities. It establishes Coast Guard as the sole authority and EPA under a consultation role in certain areas. It eliminates state regulatory authorities for all covered vessels and discharges, and fully exempts commercial vessels less than 79 feet and all fishing vessels from any federal or state management. Next. So just quickly, the definition of incidental discharge is that if the discharge into the navigable waters of the United States from a commercial vessel of 36 different effluent streams. So this table identifies those 36 effluent streams. So ballast water is the big one, upper left. The ones that are in the reddish color are the big ones that affect invasive species. So ballast water is the well-known one. Underwater ship husbandry effluent, that's all the stuff you can scrape off the bottom of a vessel, which is what we call biofouling, which science has shown is equal to, if not a greater pathway risk for invasive species on commercial vessels. There's also chain locker effluent down in the lower one. That's another one that we're concerned about for pathways of invasive species. The other ones are primarily water pollution issues, and the two that I've highlighted in sort of a gray-green anti-fouling hull coating leachate. So that's the stuff that you paint on the bottom of your hull to try to prevent the biofouling and a pollutant in connection with the testing, maintenance, repair of a system, equipment, or engine. Very, very broad categories, which are not well defined under VETA, what the extent they could be. I'm going to hand it over to Joe now.
All right. VETA expressly addresses the scope of state rights. And in the second half of the slide, it expressly preempts them. But I'll talk about Section 10 first. This pretty much quotes it. The Secretary of Coast Guard may enter into an agreement with the governor of a state that would authorize the state to enforce the provisions of the act as the Secretary considers appropriate. There's no further guidance there on how much discretion the Secretary would have to allow any states to do that. The preemption is under Section 11, and it is very express. It says, except as provided in subsection B, and as necessary to implement an enforcement agreement addressed under Section 10, no state or political subdivision thereof may adopt or enforce any statute, regulation, or other requirement of the state or political subdivision with respect to all incidental discharges and ballast waters. And as Alan just pointed out, the definition of discharge is huge, 36 different categories. So it really does prevent states from doing a lot of things that, at least in Washington state, that the state has been regulating thus far. We don't have it in the slide, but it says except as provided in subsection B of Section 11. That is a carve-out, and it is a carve-out very narrowly targeted towards land transport of vessels. So states that are concerned about smaller boats being trailered from one water body to another can still implement their state authority for overland transport of vessels or any other equipment going from one water body to another to try to address that pathway. So the preemption focuses on the vessels in the water. The intent expressly preempt states here is 180 degrees contrary to Congress's intent as spelled out in the Non-Indigenous Aquatic Nuisance Prevention and Control Act of 1990. In that act, Section 1205 of the act was expressly clear that it was preserving and protecting the rights and authorities of states and political subdivisions to adopt and enforce their own control measures to address aquatic nuisance species. And every version of VETA that we've looked at has expressly gone into NANPACA and amended 1205 in a variety of fashions, but all of which were to ensure that the express preemption in VETA carries forward, that states cannot rely upon the Section 1205 of NANPACA to do any state authority. So the most recent version of S-168 that we've looked at is Section 12E. It's hiding in the very bottom of the bill under Section 12E that removes ballast water and incidental discharges from Section 1205 of NANPACA. VETA does have some exemptions, and that is under, we forgot to write what section this was.
Section 8.
Section 8, okay. Application of certain vessels. So no permit shall be required under the Clean Water Act, which is Section 402, or prohibition enforced under any other provision of law, nor shall any best management practices regarding discharges, incidental to normal operations of vessels under this title, apply to the discharges incidental to commercial vessels if they're less than 79 feet in length or fishing vessels. So this is a blanket exemption for vessels under 79 feet or commercial fishing vessels. And it's very broad, given the express preemption in this bill, coupled with this broad language of or prohibition enforced under any other provision of law, which arguably could cover state and local attempts to regulate as well. So this leaves a gaping hole, which EPA at the very bottom of the slide estimated could be about 120,000, 140,000 vessels. Alan, is there any breakdown across the states of that number?
No, each state has a different number. Our Washington state would have a lot of fishing vessels coming in. Coastal states would have more of that, but it would affect internal or interior states as well. So whatever meets that definition, barges, tugs, other commercial fishing vessels that would probably be smaller would be affected by this.
Right. Would be exempted.
Would it be exempted?
From control completely.
Yep.
Okay. So opposition. There has been a lot of opposition, but it's prevented the bill from getting enacted thus far. But there are still repeated efforts in Congress to push it through, notwithstanding all its opposition. This is just some. National Governors Association sent a letter in May of 2017. I've got another slide that'll touch on that. 10 states, including Washington State, sent a letter in February 2017. That's also on the next slide. 10 senators sent something. Western Governors Association, AFWA, multiple state natural resource agencies, and on and on. Tribes, 89 environmental groups, and many more. So there has been vocal opposition, but for whatever reason, it hasn't been enough to completely shut down this effort. This effort still has a lot of traction in Congress. Regarding the objection letters, so in February of 2017, the 10 states are listed there, sent an opposition letter to the committee chairs that were considering the bill. And the main points in that letter was they talked about how, given the massive economic and environmental harm that an aquatic invasive species outbreak would impose on a state, the states really need to be able to maintain their own direct authority to deal with the problem. It objected strenuously to the complete elimination of Clean Water Act protections and the transferring the control of the U.S. Coast Guard, which the letter points out doesn't have water pollution expertise, and that's just not their mandate. And why should the states trust the U.S. Coast Guard picking this up when the states are boots on the ground already doing these types of programs? And it also objects to the provision that strips out the state authority under NANPACA. The National Governors Association objection letter was very short, also focused on S-168, and just straight up front said we completely object to the preemption of state authority. This should be a partnership, which, how NANPACA was written. NANPACA was very clearly a partnership, and this letter says, yeah, we want to keep doing that. And they point out that the standards that VETA imposes on ballast water are weak and wimpy and absolutely insufficient to protect our waters.
So there's been various versions of VETA that have been, discussion drafts that have been circulated amongst people, but not publicly available. So these accepted agreements are what we've heard that the Senate Committee on Commerce, Science, and Transportation majority has reportedly approved, and we want to make sure that there's no backsliding on that. So some of the things that have been negotiated so far is that best available technology, economically achievable language has been inserted for consistency and application of Clean Water Act case law. EPA's role has been enhanced in their ability to raise the ballast water discharge standard, as well as in developing incidental discharge best management practices. It has added West Coast state regional requirements into the federal law. So, for example, West Coast states require vessels to do a ballast water exchange for coastal voyages outside 50 nautical miles. That's been added to the negotiated version. It also requires the Coast Guard now to work cooperatively with the states. Again, before it was may at the discretion of the Coast Guard. Now it's definitely the Coast Guard has to work cooperatively with states to enforce federal requirements. And then it keeps the state VGP authorities for incidental discharge active until the Coast Guard issued final rules. The original version would have basically preempted the states from enforcing incidental discharge regulations during that gap.
Wasn't there a fees provision as well, that the states that had fees could still charge some fees?
Yeah, and so that's been included, the authority to issue fees to fund regulatory programs. So that was a big give.
Okay.
But only if they have already
pre-existing
fees. Outstanding issues, at least you know, the exemption on the small commercial vessels less than 79 feet and the all fishing vessels, that's a big one that I'm really scratching my head why people aren't really, you know, really opposed to it. And that's one of the issues nationally that I think, you know, really needs to be addressed. And I just want to make the caveat here that this presentation does not attempt to describe any of the Great Lakes or East Coast issues or agreements that they've made or outstanding issues. Yeah. That's it. We're available for questions.
Okay, and Joe and Alan, if it's okay with you, we will hold questions till the end. Are you guys able to hang out till then?
Yes.
Yes.
All right. Then our next speaker will be Helen, I think, if I've got. Okay, I do not see Helen signed in yet. So Stephanie, are you there?
Yes, I'm here.
All
And
right.
I know Helen, I think, got sick yesterday. She was trying to be on, but maybe she needed to go home, so that might explain why she hasn't logged in.
Okay, and so you will now be presenter.
Okay, great. Thanks.
Okay, and it is turned over to you. Okay.
Okay. Great, thank you. So thanks everyone for joining us today. Yeah, I just wanted to give an update on the building consensus in the West activities that have been happening around the model legal framework for state watercraft inspection and decontamination programs. I believe that this effort has been talked about before in previous NESAWs, and so wanted to give a little bit of background for those of you that might not be familiar with the effort, but try to talk a little bit about kind of where we are now and, you know, next steps for the future in case there's people who are interested in becoming involved. But first, before I started, I just wanted to give a shout out for our partners and funders in the project. So the National Sea Grant Law Center has been leading this particular component of the building consensus work with the Association of Fish and Wildlife Agencies, and Priya Nanjapa is our partner on that. But this is happening within the context of the Western Regional Panel, who is kind of the home for the Building Consensus Committee. But the work related to the model law and the legal framework has been funded by the U.S. Fish and Wildlife Service. And so we're very grateful for their continued support that has allowed us to work with the partners over several years. So this slide is I just include this to illustrate that although we have been working with the Western states to develop this framework, it is a national issue with the trailering of recreational watercraft across the country. This image just shows the home residence of boaters that were coming into a watercraft inspection station in Idaho. And so each pinpoint there is their home residence and how far they then trailered their boat into Idaho when they were stopped at an inspection station for the invasive species checkpoint. So boats are traveling huge distances overland, many coming from the eastern United States, where there are large populations of quagga and zebra mussels, which are the primary concern currently for the western United States, although there are many other species that are moved in that pathway. And kind of keep this image in mind for then a couple slides when I talk about, you know, kind of what the current legal framework looks like. And this is the slide. So one of the places we started was to say, you know, what's out there, what's on the books on the state level with respect to recreational watercraft. And so 62% of the states do have some legal provisions addressing the trailered recreational watercraft vector. But you can see they are very concentrated geographically. The big red splotches there are states that don't have any relevant provisions. So these states may have invasive species programs, and they have a lot of state laws with respect to noxious weeds or restricted fish and animals, but they don't actually have provisions on the books specifically for the overland transport of watercraft. The states in green are states that have what we consider a full or partial watercraft inspection and decontamination program. And so these states are requiring that boats be clean, drain, and dry, comply with inspection requirements such as stopping at stations that are manned by state personnel or trained volunteer to inspect the vessel to determine the risk that that vessel might be transporting invasive species. And then there's a handful of states, those marked in blue and purple, that either may restrict the movement of watercraft with aquatic plants attached, for instance, or maybe require drain plugs to be pulled so that the compartments are drained before they're moved to another water body. Some also have launch restrictions. For instance, they might prohibit the launch of a vessel that hasn't been drained or hasn't complied with state law. And then a couple of states, New England, New Hampshire, and Maine, that have courtesy boat inspections. So these are voluntary programs run by volunteers, primarily focused on outreach and education to get boaters to clean, drain, and dry primarily, and remove aquatic plants. So there's a whole range across the country of where states are. And the Western states have really been trying to work towards some sort of framework that would allow reciprocal acceptance of recreational watercraft coming through state checkpoints from low-risk waters. And so these are boats that might not pose a high risk of invasive species introduction. The states still want to stop and look at those boats and talk to the operators as they're moving through the state, but they would like to try to get to where they could share resources among the states, maybe rely on some of the initial risk assessments that a previous state has looked at. If you think back to the map with the checkpoints, some of those boaters are driving through 4 or 5 states on their way up to Washington or Oregon. They may get stopped multiple times, and so boaters would like to, have similar, or the states would like boaters to experience similar interactions with their inspection personnel as they're moving through there. And so they started with this idea of a model law as the foundation, and then working towards a model regulation with model protocols and standards. Those are being developed by different committees within the Building Consensus Initiative. Many of the documents that have been produced through those committees are issued by the Pacific States Marine Fishery Commission, and they can have that type of scientific analysis going behind the protocols and standards, and then ultimately working towards a model memorandum of agreement that states could use if they wish to work together. Now, one of the unique aspects we think of the Building Consensus Initiative is that it has been focused on building policy consensus to be that foundation for the legal framework. And it's done by bringing together 3 groups of people who are not often brought together in the same room. And that's the AIS coordinators, who are the kind of subject matter experts. They're the ones on the ground working in the agencies to implement the programs, but we bring them together with assistant attorneys generals from the state and law enforcement, so that we have the folks that are either writing or providing advice on implementation of the law with the enforcement officials, as well as the subject matter experts. And we're doing this because we think it's an important mechanism to enhance the intra and interstate cooperation and communication. You really need to get everyone in your state on the same page about what your policy goals are before you can then start working across state lines. And then when you're ready to work across state lines, everybody needs to be talking in the same language and also trying to work towards similar goals. No one's going to be identical, but you are all trying to row in the same direction. And so the foundation of the effort is to try to harmonize state laws, regulations, and policies, enhance implementation and enforcement through reciprocity or other agreements, and to also help coordinate the outreach messaging. The how, so the role that the National Secret Law Center has been playing is to provide information to support these discussions and to provide resources for the states and their partners as they try to move forward. So we have done research on the existing legal framework for watercraft inspection and decontamination programs in the Western United States, but we've also, as the graphic from earlier slides illustrated, started to look at programs nationwide. And so we do also compile information on the laws and regulations in the Eastern and the Great Lakes states. And then we look at the legal barriers, whether those are real or perceived, to interstate cooperation, and bring people together to talk about how to overcome those barriers. And then we have also developed and maintained a compilation of state laws that are relevant to these programs, so that when states are undertaking legal reform efforts, they have a resource that they can come to answer questions of state legislatures. For instance, like if you're looking at drain plug provisions, sometimes the legislature likes to know how many other states have taken a similar action. So our compilation can make it a little easier to timely produce that type of information. And then the Building Consensus Initiative, through many different funding sources and just the generous in-kind support of all the states that have been involved, have been able to facilitate a number of face-to-face meetings. And we convene the AIS coordinators, assistant attorney generals, and law enforcement officials in the same room. And they've all attended the different meetings at various levels. They don't all come to every meeting, but they're all involved in aspects of the discussions. Our first meeting was in Phoenix, Arizona in 2012. Then we've tried to meet every year as much as possible. We had a snowstorm, I think in 2016, that kind of threw us off, but we have managed to have sustained participation now for going on 6 years, which is pretty amazing that the state agencies have been so supportive of their staff participating in these discussions. And then the steps were, once we, got folks in the room and they were able to agree on some of the policies that they wanted to move forward, the question became how to translate that consensus policy into state law. And that's where the National Secret Law Center and AFWA have been working to produce these resources. So the first one was the model legislation that we issued in 2014. And like Joe Pinesco, our former panelist, was involved in that effort, along with several other assistant attorney generals from Western states. After we issued the model legislation, we started to get a lot of questions about, so where do states fall within this model, right? How close are states to the authorities? What the model legislation does is outline model authorities that the group thought was necessary for state agencies to have in order to implement an effective watercraft inspection and decontamination program. Our documents are not intended to be adopted verbatim. In many cases, the states have lots of the pieces of the authority that we discuss, and we don't anticipate states going back and kind of wholesale revising their invasive species laws and policies. But what the objective is to provide model language or ways to think about how to provide authorities for different aspects of the program, such as training of personnel or where do you place your check stations, those type of conversations. And so we followed the model legislation up with a gap analysis where we looked at across the country, how did states match up to the model, which has just helped the states when they go into conversations about how they would like to change their legislation, they can kind of see where they might be missing things that a lot of other states have. That was followed up by a model regulation, which was issued in 2016. This stepped down the authorities that were outlined in the legislation to look at, okay, what do we need now that we're implementing the program, and what do we need to make it easier to work across state lines and to work with partners in neighboring states. And so the model regulation was really looking at how can you create or design a watercraft inspection program in such a way that might make it easier to work with your neighboring states. That was followed up by an update of the gap analysis, because there were some provisions in the model regulations that were not talked about in the model legislative provisions. For instance, we added things related to training of personnel and drain plugs to the model regulation. So we wanted to go back and expand our gap analysis to cover, everything that we were talking about. And then this year, we're starting on the final piece of the model legal framework, which is the model MOU. And this will just be to outline things that states should consider if they want to enter into an agreement with a neighboring state or, even a state a couple states away, to share resources or work together to achieve their watercraft inspection goals. We've actually it's been amazing to see the states being able to use the resources that the Building Consensus Initiative is adopting to move their programs forward. So almost a dozen Western states have amended their laws and regulations to incorporate consensus policies and model authorities, and that can be seen through the updates in our gap analysis that we actually have more states with authorities that they didn't have before that they are adding because of the building consensus process. The model legislative provisions also inform development of the new watercraft inspection programs in several of the Western Canadian provinces. And so that was really helpful for them because they were able to come in or come online kind of consistent with their neighbors to the south were doing, which has made it easier in some ways for them to join in the discussions and to kind of build off of the work that was already done. And then the Western Association of Fish and Wildlife Agencies issued a resolution in 2016 that has really helped to sustain the process as well, because they recommended adoption of standardized regulations with respect to drain plugs and visible plant material on watercraft and trailers. And so that has been helpful to the state aquatic invasive species coordinators to have the support of their agencies in moving some of these reform efforts forward. So some of the next steps, as I mentioned, the development of the model MOU, but we are also working on professional development and training workshops for policymakers that may come in late 2018 or early 2019, depending on the timing of some meetings that we're looking at kind of coordinating with. But there we hope to bring in representatives from the Attorney General's offices, but also staff, legislative staff that might be working on legal reform efforts so that they could talk about what challenges remain, things that might be missing from the resource documents that could, help them move their programs forward. We'll continue to update our comparison report as changes happen. The Western United States has been very active in amending their legislation and regulations, and it can sometimes be hard to keep up with everybody, but we continue to do as much as we can to make sure that our information is as current as possible so that the states can have that information at their fingertips if they need it. We would also like to expand our legal compilation to include the Canadian provinces, so people have a little more access to that information. And there are some tribal governments that are implementing watercraft inspection and decontamination programs, and their laws are a little more difficult at times to access, and we would like to see our legal compilation be used to kind of move those, enhance accessibility of the tribal laws. And so encourage you to visit our project website where all of our documents are available. If you have any information that you would like to share with the Western states, or would like more information about how we put the comparisons together, or would like information about kind of the committees and who was involved, I'm happy to talk at any time. And I think with that, we could open up with questions.
Okay, thank you very much for that, Stephanie. And I see that Helen is ready to do her presentation. We're having a few issues though. So while Helen is checking on an email I just sent her that should give her the information she needs, we'll check and see if there's other questions for the presenters that have gone already. Let's see. All right, if you have questions for one of the three presenters that we've heard today already, if you would type that into the question box, then I will read that aloud for everyone. And I see, let me check. Okay, yep, I still don't have Helen. Helen, we need you to sign in as a presenter. The last email that I just sent you, if you'll open that Excel file, that has the information for you to sign in as a presenter. And I think that's the issue because you're signed in as an attendee now. While we're waiting, I would like to thank the National Invasive Plant Council for arranging these webinars, and especially Sherry Williams. She did the vast bulk of the work for arranging everything, contacting the speakers and arranging the schedule, and we're very grateful to her for that. She's done a great job and got a great lineup of speakers. And thank you also to our speakers for that. This has been very interesting. Yesterday, talking about some of the tools that are now available to use in some areas and will eventually be available to use throughout the U.S. and Canada. And those are available now for the Southeast. And now we've looked at today some of the laws and other regulations that are being worked at together by the Western states to make things more consistent across that area, and will hopefully be taken up by the eastern part of the U.S. too. So it's great partnership, everybody working together and learning from each other. Let me see if we've got Helen on yet. Okay, we've got one question. Says, I'm not in the industry, but curious how difficult enforcement is with recreational boat owners. How do you catch them?
Hi, this is Stephanie, and Alan would probably have a lot more specifics, but the image that I showed about the check station is most of the Western states strategically place inspection stations. So booth, or if you think about like a roving checkpoint for like when we think about drunk driving or alcohol checkpoints, the boat inspection stations are similar to that. They're either placed at a water body or maybe at a border station where boats, and major highways where they're coming in. And so the idea is to try to kind of catch them as they're traveling along major transportation routes. And the laws in the Western states require boaters to stop at check stations when they're opened and being manned. And there have been enforcement challenges over the years. Sometimes boaters will drive past them. And so some states have had to go back and amend their laws to give police and enforcement officials the ability to go and force a boater to come back to stop at the check station. On a highway stop, for instance, it might be a little easier if you're stationed at a water body, since they'd have to go past you to launch the boat. But I think that might be the kind of the basic approach to the question.
Okay, thank you, Stephanie. And let's see, then we've got another question asking about the presentations. Yes, these presentations have been recorded, and they will be available on the NESAW and the National EPSI websites by the end of the week. And all of the webinars this week will be done that way. Okay, we're still having...
this is Helen. Can you hear me?
Yes, yay, Helen, I can hear.
Okay, well, at least you can hear me. That's a good sign.
Yes, now if I can hear you, okay, I'm going to try to, all I'm seeing is Joe signed in. Okay, let me see if this will, if I change presenter. Okay, I'm still not seeing. Okay, let me see if this will let me do this. Hold on one second. I'm sorry for this, y'all, but technical difficulties do tend to arise with this technology. I'm going to see if I can do this to make Helen a presenter. Oops. You need to enter your PIN, Helen. There should have been a PIN along with audio PIN has been sent.
So the PIN that was sent to me, I did enter the PIN, a different PIN, multiple times. I received several different emails with specific information, and none of the PINs apparently.
Okay, and I've just
in the Excel spreadsheet that you sent me, that access code did enable me to have this audio, but there was no PIN on that.
And I've just clicked on your name and asked it to send you a PIN, so that may be, can you see us on the screen?
Yeah, I've been able to see the screen the whole time.
Well, if you, is there an area there that says audio PIN? Has a
no.
I'm not sure on your screen where it would be. Audio.
I'm seeing your audio. Hold on, let's see. Okay, yes.
Okay, try that.
Well, no, that's your screen. When I click it, it says muted, enter audio PIN, which I've already got audio, and this is on your screen, so.
Okay.
I mean, I hate to take up everyone's time. I suppose I could, it's only 7 slides. I suppose I could talk through it without it, but that's.
I hate to do that. I hate to do that.
Oh, could she email the slideshow and just direct you to click through the slides?
Absolutely. As a matter of fact,
Brilliant.
absolutely. Very brilliant.
Okay, let me do that. I'm doing that now.
I may have that. Let me check.
I don't think you do.
Okay.
I mean, because I was out sick yesterday and I wasn't sure how this was unfortunately all going to go down. Now I know. Let me see.
And you do have krollins@uga.edu?
Yes, I'm responding to the
one I sent you.
email that you just sent me. Yeah.
Perfect.
Okay, let me see. And there we go.
All right, and what I'm going to do is tell it
I did send it, so just let me know.
all right, and here it is. Oh, yay. All right. And now the test, can you'll see mine?
Okay, perfect.
Can you see my screen?
I can, yeah.
Okay.
Yeah, put it to the view slideshow setting.
Yeah. And I'd also like to say that I believe also on this webinar are Sue Jewell and Tim Van Norman at Fish and Wildlife Service, and Sue is the Fish and Wildlife Service's Injurious Wildlife Listing Coordinator. And Tim Van Norman is chief for the branch of permits within the Division of Management Authority, and they were going to be online to respond to any questions with respect to how the service was responding and implementing this decision. But now, understanding the nature of this webinar, I'm not sure that they would have any audio to respond. Would they be able to be unmuted, or would they be?
I think I can unmute them.
Okay.
All right. If you send them your sign in, they're signing in as a presenter, and then they would be unmuted. But I think I can unmute individual attendees as well. And I say,
okay, so by my sign-in, do you mean the Excel spreadsheet? Because again, I got several different sign-in emails, and the only one that gave me this audio was the Excel spreadsheet you just sent me.
Right, so that would be the one to send them.
Okay, I'll do that while.
So are y'all seeing the proper screen now?
I am.
Okay.
Sorry, give me just a minute to send this to them. I'm not very great at multitasking, apparently. Okay. All right, thank you everyone for your patience. My name's Helen Spites, and I'm an attorney with the Department of Interior's Office of the Solicitor. I'm in the Division of Parks and Wildlife, specifically in the branch of Fish and Wildlife, and I was asked today to discuss litigation filed by the United States Association of Reptile Keepers, or we always also call them USARC. That litigation was challenging the Fish and Wildlife Service's listing of 8 constrictor species as injurious under the Lacey Act. The central issue in this litigation was whether the Lacey Act prohibited shipments of injurious wildlife from one of the 49 continental states to another. But before we get into the specifics of the litigation and that decision, I'd like to provide a little bit of background on the Lacey Act and the service's interpretation over the years. Next slide.
It's being slow. Sorry.
That's okay. Okay, the Lacey Act is a law that dates back to 1900 and is one of the oldest conservation laws in the United States. A central purpose of the Lacey Act is to regulate the introduction of American or foreign birds or animals in localities where they have not existed. At its enactment, excuse me, in 1900, Section 2 of the Lacey Act made it unlawful to import birds or animals without a permit. It also prohibited the import of the mongoose and a couple of other specifically mentioned birds and any other birds or animals that the Secretary of Agriculture declares to be injurious to the interest of horticulture or agriculture. And these importations were prohibited unconditionally, thus no permits could be issued for them. And at the time of enactment in 1900, Section 3 prohibited interstate transportation for unlawfully imported species and prohibited interstate transportation of wildlife killed in violation of state, territory, or the district where it was found. Between 1900 and 1960, there were various amendments. In 1939, in the context of amending the Migratory Bird Hunting Stamp Act, Congress stated that a central design of the Lacey Act was to prohibit shipment and interstate commerce of wildlife killed or shipped in violation of state laws, and then purported to extend the operation of the Lacey Act to foreign commerce in game and wildlife. And this language didn't speak to injurious species specifically. But then, importantly, in 1948, Section 2 became Title 18, Section 42 of the United States Code, and Section 3 became Title 18, Section 43 of the United States Code. And Section 42 continued to speak only to unlawful importations and importations requiring special permit, while Section 43 of the 1948 amendments prohibited interstate transport for unlawfully imported species and prohibited interstate transport of wildlife killed in violation of state, territory, or other laws. Now, then the Act was amended in 1960 to add the statutory language that was at issue in the U.S. ARC litigation. The 1960 amendments added to Section 42 the language regulating the shipment of injurious species between the continental United States, the District of Columbia, Hawaii, and the Commonwealth of Puerto Rico, or any possession of the United States. Specifically, 42A1 states, the importation into the United States, any territory of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or any possession of the United States, or any shipment between the continental United States, the District of Columbia, Hawaii, the Commonwealth of Puerto Rico, or any possession of the United States of and such other species of wild mammals, wild birds, fish, including mollusks and crustacea, amphibians, reptiles, brown tree snakes, or the offspring or eggs of any of the foregoing, which the Secretary of the Interior may prescribe by regulation to be injurious to human beings, to the interest of agriculture, horticulture, forestry, or wildlife, or the wildlife resources of the United States, is hereby prohibited. The Fish and Wildlife Service subsequently amended its regulations at 50 CFR 16.3 in 1965, including very similar language. And then also at the time that Congress amended Section 42 in 1960, Congress amended Section 43, and when describing the prohibition of interstate transportation of certain wildlife, to read that whoever delivers, carries, transports, ships by any means whatever, or knowingly receives for shipment to or from any state, territory, the District of Columbia, the Commonwealth of Puerto Rico, any possession of the United States or any foreign country. And so that Section 43 is now codified at Title 16 USC, the United States Code, Section 3372. Next slide. Okay, so admittedly, the early interpretation of this provision was not clearly articulated. In fact, the service first provided its interpretation of the shipment clause in 1982 when it listed the raccoon dog as an injurious species under Section 42A1. And the Fish and Wildlife Service's environmental assessment on the proposed listing contained language prohibiting the interstate transportation and clearly showed that the service did view this provision as prohibiting interstate transportation. However, the service listed a number of other species between 1960 and 1982, and none of them provided an interpretation of the prohibition. However, beginning in 1989, the department began inserting language in rules listing species as injurious that purported to prohibit all interstate transportation of the listed species. And the service's interpretation was communicated to Congress through testimony on various bills after 1990, and legislative history since that time has indicated that Congress understood the Lacey Act to prohibit interstate transportation between the continental states. In 2012 and again in 2014, Congress enacted legislation to exempt from the Lacey Act water transfers by a facility moving water containing injurious zebra mussels and other injurious species between Texas and Oklahoma. And this legislation obviously wouldn't have been necessary if transport of injurious species across state lines within the continental United States was not prohibited. Legislative history associated with these exemptions also confirms that Congress understood the Lacey Act to prohibit transport of injurious species between states within the continental United States. So, prior to this litigation, the service had been interpreting the Lacey Act to prohibit the transport of injurious species across state lines within the continental United States for about 30 years. Next slide. Okay, on January 23rd, in 2012, the service published a final rule listing 3 species of non-native pythons and 1 non-native anaconda as injurious under the Lacey Act. And in that rulemaking, the service stated that by taking this action, it was prohibiting the importation into the United States and interstate transportation between the states, the District of Columbia, the Commonwealth of Puerto Rico, or any territory or possession of the United States, except by permit. The USARK filed a lawsuit then in December 2013 challenging that rule, and the complaint alleged 4 separate counts. One, that the 2012 rule's prohibition on interstate transportation of listed snakes was ultra-virus under the Lacey Act or beyond the scope of its powers. 2, that the service failed to take a hard look at the environmental consequences of listing the snake as required under NEPA, under the National Environmental Policy Act. 3, that the service should have prepared an environmental impact statement under NEPA. And 4, that the service acted arbitrarily and capriciously in violation of the Administrative Procedure Act in deciding to list the 4 species of constrictors. USARK was later granted leave to file a second amended complaint, which added a challenge to a new 2015 rule listing an additional 4 constrictor species. And that second amended complaint also added 4 individual plaintiffs and a claim under the Regulatory Flexibility Act. Next slide. So on April 1st, 2015, USARK filed an application for a temporary restraining order asking the court to enjoin the service's implementation of the 2015 rule as applied to the 2 of the species, to the reticulated python and the green anaconda, which the rule was scheduled to take effect on April 9th, 2015. Their application for a TRO raised only the challenge to the scope of the Lacey Act injurious wildlife provision and the Regulatory Flexibility Act claim. So that was all that was before the court. At a hearing, the court denied the application for the temporary restraining order, but converted USARC's filing to a motion for preliminary injunction and ordered supplemental briefing. So in that briefing, the government argued first that the claims were time barred. They said that the service had been interpreting the Lacey Act in this manner for a number of years, certainly more than 6 years, and so plaintiffs had notice, and their claim was barred by the statute of limitations. Alternatively, the government argued that the plain language of Section 42A1 supported the service's interpretation. We argued that Congress's use of "or" in the statutory language affords each listed locality independent significance, such that shipments of injurious wildlife are prohibited between each one, including shipments between the United States. And we argued that the District of Columbia is listed separately because Congress wanted to include each political entity that is potentially involved in the interstate commerce of injurious species. And we said that, under USARC's reading of 42A1, an individual that was transporting listed wildlife from Virginia to Maryland would violate the statute if he drove through the District of Columbia, but not if he drove around the Beltway. And we argue that that kind of distinction is unrelated to any conceivable purpose of the Lacey Act and would produce an absurd result. We also argued that the purpose of the Lacey Act supports the service's interpretation of the Act's injurious wildlife provision. One purpose of the Lacey Act is to regulate the introduction of American or foreign birds or animals in localities where they have not existed before. The Act states that the localities are the geographic entities that should be protected, not merely large territories like the entire continental United States or an entire insular territory. And to protect localities, Congress could not have intended to cabin the service's authority to prohibit only the transport of injurious wildlife from the District of Columbia, Hawaii, Puerto Rico, and other U.S. territories to the continental United States. And finally, we argued that even if the court were to find that congressional intent in 1960 with respect to the transportation prohibition is not clear, Congress's actions since 1960 have ratified the service's interpretation of the prohibition. We said that Congress's actions in 1990 and in 2010, amending Section 42A1 to add the zebra mussel and the Asian carp, show that Congress intended to prohibit interstate transport of injurious wildlife from the Lacey Act, from the time the Lacey Act was first enacted. And there were also some questions as to whether or not the service should get deference if the court found the statute was ambiguous, given that this was a criminal statute versus a civil statute. We argued that there's no distinction between criminal laws and civil laws that call for criminal penalties, and the service's reasonable interpretation would require deference in that case. Next slide. So, unfortunately, on May 12, 2015, the district court found that USARC was likely to succeed on the merits of its claim, challenging the service's long-standing interpretation of the statutory prohibition against interstate transport of injurious species between states within the continental United States. And they enjoined the service from implementing and enforcing the Lacey Act's transport prohibition for the reticulated python and the green anaconda within the continental United States, except for transport into Texas and Florida. If you remember, those were the only two species that they had brought into their motion for preliminary injunction. First, the court found that the government's position that the action was time barred was seriously flawed. I believe those were exact words. It noted that the final agency action at issue was the promulgation of a 2015 rule, and in any event, the rule reopened the question of whether or not the department's interpretation of the relevant Lacey Act provision is correct, and the suit was thus held. The suit was timely filed. The court then questioned whether or not Chevron deference would apply, whether the service should get deference if it found the statute ambiguous. Sorry, I'm getting a little bit of an echo pushback. But it ended up saying it didn't need to reach that issue since the court did not find the statute to be ambiguous. While the court found that the plain language of the Lacey Act did not compel either side's interpretation, it did note that Congress used very different language to prohibit the interstate transportation of certain wildlife species in Section 43 of the 1960 Lacey Act amendments. And it said that, it could have used that clear language to prohibit the interstate shipment under Section 42 as well. And the fact that it did not was an indication that Congress did not intend the prohibition on shipments under Section 42 to reach as broadly as the service's interpretation would have it. The district court relied heavily on the legislative history, and here it found that the legislative history of the 1960 amendments unambiguously, quote unquote, supported plaintiff's position. And the court relied on a Department of Interior staff's testimony and other statements in the legislative history to find that the amended language in 1960 was not intended to dramatically expand the scope of conduct prohibited under the Lacey Act. Before the 1960 amendments, the Lacey Act barred importation into the United States or any territory or district, but did not address their domestic transportation, and said that Fish and Wildlife Service's interpretation would have Congress criminalizing a broad range of activity as opposed to merely clarifying certain provisions as testimony in House and Senate reports suggested. The court also found the narrow reach of the 1960 amendments to be confirmed by the Department of Interior's interpretations in the 2 decades following its enactment, so up until before, 1982 to 1989, when it started voicing its interpretation consistently. The court did acknowledge that subsequent enactments show that recent Congresses have understood that the Lacey Act prohibits transport of injurious species between states within the continental United States. And this includes 2 times where Congress has amended Section 42A to add injurious species on its own, and the one situation where Congress passed legislation specifically to exempt a facility engaged in water transfers containing zebra mussels between Texas and Oklahoma. Nonetheless, the court rejected the government's arguments that Congress ratified the agency's interpretation because it had already concluded that the meaning of the Lacey Act's relevant language was clear at the time of its enactment in 1960. The court also addressed and dismissed the argument that the Lacey Act prohibition was implicitly amended through Congress's subsequent amendments to add the zebra mussel and bighead carp, and then enacted legislation to exempt certain water transfers between Texas and Oklahoma. In doing so, however, the court acknowledged that the question is close on whether Congress's amendment of the Lacey Act to add the bighead carp impliedly amended the Lacey Act, and conceded that it was evident that the principal purpose of the 2010 amendment to add the bighead carp was to prohibit interstate transportation of bighead carp. However, the court continued to rely on what it said was a lack of information in the legislative history indicating that Congress intended to criminalize the interstate transportation of all species as opposed to just the bighead carp, currently listed under the Lacey Act. Next slide. Okay, so now with the district court's decision, reticulated pythons and green anacondas could be transported without any meaningful restriction throughout the continental United States, except to and from the District of Columbia and into Texas and Florida. While the order precluded the two species from being transported into Florida and Texas, pets and other animals in captivity could still escape or be released and survive in adjoining states long enough to migrate south into Florida and Texas, where they might find long-term suitable climate conditions and habitat. So there were strong concerns about the service's ability to prevent those efforts. And also, you know, the court's order was limited to named plaintiffs and members of USARK organization, but USARK is not a small organization. So again, there was strong concern that this decision would pose a severe impact on the service's ability to prevent the establishment and spread of injurious species that have already been imported into the United States. And, you know, also the government believed that the court got it wrong, that the court erred in finding that plaintiffs were likely to succeed on the merits of their statutory interpretation claim. And so as a result of these concerns and these findings, the government appealed to the DC Circuit. And the government again argued that the plain language of Section 42 supports the service's interpretation, that the legislative history shows that Congress intended to prohibit the interstate transportation of injurious wildlife from the time the Lacey Act was enacted. And alternatively, we argued that Congress ratified or impliedly amended Section 42A1 to comport with the service's interpretation with its activities related to the zebra mussels and bighead carp. And finally, we argued that, you know, even if the court does find the statute to be ambiguous, the service's interpretation is entitled to deference. Then, again, unfortunately, on April 7th, 2017, the DC Circuit upheld the district court's decision and went further than that. It actually reached a definitive judgment on the shipment clause's meaning. It held that the service lacks the authority under Title 18, Section 42A1 to prohibit shipments of injurious species between the continental states. The DC Circuit found that this provision was unambiguous and found that its interpretation of this provision was consistent with the legislative history. And specifically, it held that USARK's interpretation was mandated by the grammatical structure, stating that the words between, when used to introduce multiple items, so between the United States, the District of Columbia, etc., speaks to the relationship across the listed items and not to the relationship within any one of the listed items. And it essentially said that the use of or later in the clause could not overcome this fact. So they spent actually several pages giving the Fish and Wildlife Service a lesson in grammar, it seemed. They found that their interpretation was consistent with the evolution of the Lacey Act, noting that the 1960 amendments that added this language in question were just meant to broaden the statutory language, the existing statutory language a bit. And they noted that Congress could have used the same language that it did when it amended Section 43, but it did not. And the court found that the government's arguments as to ratification and implied amendments could not overcome the plain language of the act. And the court stated then that as a matter of law, the government lacks authority under the shipment clause to prohibit shipments of injurious species between the continental United States. So now, because of this decision, existing and future injurious wildlife listings, including those that were listed or have been listed by Congress through statutes, will no longer result in a statutory prohibition on interstate transportation of injurious wildlife between states within the continental United States. And that's my summary of the decision. And again, there are folks from the Fish and Wildlife Service if there are questions as to how the service is responding and implementing this decision.
Thank you very much, Helen. That was interesting. We should have all been listening better in grammar, in our grammar classes.
I know, right?
Let's see if we've got questions here. I think this one might be for Stephanie. And please go ahead and type your questions in if you have questions for any of our presenters. Can you provide more details about what is covered in the MOUs?
Yes. So we actually have just started the process of working towards the MOUs. We think that they'll primarily focus on laying out the kind of boundaries for what states think have to be included in programs in like both states to move forward. So for instance, we would anticipate they would include things about what type of training or how much training personnel should have. Quality control requirements might be in an MOU. There would definitely be like documentation requirements. For instance, there's a lot of challenges when boats move across state lines if they haven't been issued a receipt that provides the inspection history of the vessel. So definitely if two states want to work together, they need to have some sort of standard documentation so that the inspectors can talk to each other. So that's the type of issues that the MOUs would try to work out so that states would know kind of what's expected for them to make their partnership work.
Thank you, Stephanie. I have a question for Helen or her group there. So this is dealing with the federal laws then, but individual states can prohibit shipment of different species into their state or across their state line. Is that correct?
Yes, that's correct.
Okay. Okay, that is all the questions that I see for now. This has been recorded and it will be available on both the NESAW and the National Invasive Plant Council websites by the end of the week. Thank you very much to all of our presenters. Appreciate the time and effort that you've put into this today. And I appreciate all of your patience with the glitches that we experienced there for a bit. And we will see you tomorrow for the next presentation, tomorrow at 4.
Thanks, everybody.
Thank you.
Thank you.